So thanks for rejoining. I'm back this time with my colleague Will White in our commercial technology team, and we're going to talk about contracts. And we're going to try and do justice to Mark's build-up to say this was normally the most popular slot in the Tech Summit. We love contracts, but we're always surprised that you all do, apparently. So what we're going to do is we're going to do a rundown of what we think is market practice across technology contracts based on an annual benchmarking review that we do based on our work and the deals we see. So we're going to focus on the main negotiated points across software as a service contracts and overlay that with how those same issues are dealt with on generative AI contracts and agentic AI now. And we'll have some Q&A at the end if there's any questions. So we'll kick off about just talking about what market we're actually talking about now, because this has become increasingly segmented when it comes to procurement and contracts, we find. So it's pretty multifaceted. So there's not really one market. So unlike when we've run this kind of session in previous years, what we're not going to focus on is sort of the large, complex outsourcing and digital transformation project contracts, which tend to be quite bespoke, systems integration or bespoke software development as well, because those are their own markets with their own norms. What we thought it would be useful to look at is what we think is more typically passing across people's desks every day, the higher volume of SaaS and now AI contracts, rather than those once in every 5-year type deals. So over to Will to explain a bit more about the different parts of the market.
Yeah. So for the purposes of this exercise, our baseline, if you like, is SaaS, traditional SaaS. And really what we're talking about here, I think, is two different markets. So one is your sort of high volume, usually low value, potentially low risk, like commodity SaaS, the kind of thing you've got dozens of, like going through annual cycles every year. But there's also a second SaaS market, I think, which is some kind of called strategic SaaS. So these are platforms that you buy on a SaaS basis that might underpin your whole business. So say an ERP like Oracle or SAP, but maybe also just something that is critical to the functioning of one of the bits of your business, like a Workday in HR or a SAP SuccessFactors or a ServiceNow. And what we often see is that those strategic SaaS products are positioned by vendors in the same way as if they were commodity SaaS products, which obviously we understand the reasons for, but is something to watch out for. But looking at the SaaS market as a whole, there are, I think it's fair to say, some pretty clear standard positions that we would normally expect to see in most supplier terms. But there is scope for negotiation on some of these deals, especially where there's something special about it, either because the value is particularly high, or because you're trying out new functionality from the vendor, or just because you're a great flagship logo client. And moving on from that, we're also going to try to give a picture of how generative AI is starting to challenge some of those established positions. Now, this is a bit of a maturing market. This has been a couple of years now, maybe even 3 years for the early adopters. And again, it's a market in two bits, I think. So you've got, on the one hand, your big LLM providers, your foundational model providers. So I think like the Googles, the Anthropics, the OpenAIs of this world who are providing the foundation models. And they're, because they've been around for quite a while, and to some extent, I think, because they're competing on legal terms, what we see is that they're always dealing on their standard terms of service, but they are often, I think most of them are converging on some common positions on key points. So there is a bit of a market standard there. And then the second half of the market is, I think, a Wild West, or as wild as contracts get. These are the wrappers around those foundational models. So normally we're thinking things like point solutions, where a company is trying to create a specific, domain-specific solution to a domain-specific problem. Like, think of a tool that tries to generate regulatory filings for you or marketing copy. And then, Vic, I think you're going to talk about the third category that we're going to cover.
Yeah, so the agentic market, I think it's coming across today from the earlier session that this is pretty nascent. We've been seeing quite a few clients do proofs of concepts and supervised trials, and we expect there to be wider deployments as the technology evolves and starts to prove out its return on investment. And I think we've already seen some of the risk categories and controls are different around agentic and can think about them differently. talked about some internal governance mitigation, but part of that mix is going to be looking at vendors on due diligence and contracting during procurement cycles as a way to deal with this. And just a point on the marketing puff around this, I do think that there's more of a permeable line between Gen AI and agentic AI in terms of how vendors are promoting them in the market. Quite a lot of the time, the distinction is more marketing than it is technology based, and a lot of products feature both types of technology. For example, if you think about some of the automated coding tools out there, they'll do autocomplete of coding supervised by a human user, more like Gen AI, or also somewhat semi-autonomous vibe coding, which is just more autonomous and more like agentic. So now we kind of know the bits of the market we're going to focus on. What we're going to do is pick a handful of issues we think are most heavily negotiated or at least represent some risks to buyers and vendors, give an update on what we think is market standard, and give an overlay of how we think AI might evolve that.
So the first issue that we're going to look at is IP ownership and customer data. And I think the key point here, and this will recur throughout all the issues we look at, is that where once there was a pretty standard position, like there was a market norm, you could say, this is what I would expect to see in a contract. Because of the evolving technology that is being licensed or that's being provided under these contracts, those positions are being challenged a little bit. They're just more complicated. There's more to think about, and people don't quite know where to settle on them. So in the SaaS world, it used to be dead simple, right? You had the supplier's core IP in their platform. That remained their IP. And you had the customer data that the customer brings to the party, uploads to the platform. That remains the customer's IP. And then you have cross-licenses to make the engagement work. Whether they should be licenses or rights of access, happy to talk about over a drink later. But a couple of points I think it is worth diving into that we've noticed become a little bit more contentious over the last couple of years. And one of those is analytics data. I'm seeing a lot in contracts at the moment, a sort of clause along the lines of the supplier may use aggregated and anonymized customer data for service improvement purposes. And I always struggle with that a little bit, and I think some of our clients do too, because if you think about anonymized and aggregated, those are terms from the world of personal data. And while obviously some of your customer data is going to be personal data, a lot of it isn't. Like sometimes it's just going to be your accounts, your business plans for next year. What does it mean to anonymize a business plan? What does it mean to aggregate your business plan with somebody else's business plan? So I think to address the risk here, a position that we are trying to get to a lot, and is usually pretty doable actually, is to instead of saying, right, here's all the customer data, so long as you put it through this process of anonymization and aggregation, you can use it, to instead say, no, here's the analytics data, it's these specific categories that have gone through this particular process, and then carve that out of the protections that would otherwise apply to customer data. And that just gives both parties certainty of what they can do and what they have to do. I think it's mutually beneficial. And then finally on SaaS, because I don't want to take up too much time on it, personal data should be dead simple in most cases. There's usually a controller to processor relationship. You know exactly what has to go into your data processing clause because it's written out in Article 28 GDPR. But honestly, the number of contracts that come across my desk where there is just something missing, a really obvious gap, I often think it is worth just doing a cross-check against the requirements of the GDPR whenever you see a controller to processor clause, because it's just an easy compliance win.
So how is IP and data rights being handled under generative AI contracts at this point? What's the state of things? So I think starting on the left of the Venn, inputs in terms of customer data used as throughput to the Gen AI tools is pretty established that the customer retains ownership of that, although in a minute I'll talk about licensing of that to supplier for training. On generated outputs are generated through the use of the services. The position is pretty much settling that customers going to own those outputs to the extent there's any IP. And that's an interesting point you've heard earlier about issues around IP and copyright in AI. But so the suppliers here are handling that by not promising that there's IP in the outputs. So you don't get an assignment. You get something more like a supplier not claiming or asserting any rights in the IP. So to the extent there is, then you can own it. And we know that the lawyers have settled on that at the moment. The exception to that market position at the moment we're finding, which is relatively new, is AI suppliers, particularly when they have invested a lot in curating their data sets, and that really kind of means some of the legacy providers who have already got very sophisticated data sets, and then they have produced new AI tooling to access those. So an example I see a lot is from the legal know-how companies, who all have their AI solutions. And if you think about that, they've invested a lot in their legal know-how for years and years and decades. And so they perceive that if you ask a question and generate an output, that a lot of their value, their data, exists in that output. So on a legal question, you might ask one of the tools that are very well known now, that might be your fact pattern or your client's fact pattern, but the actual output answer that you get is actually a form of theirs. So they see a lot of value in the outputs you generate. And in those cases, in those data-rich fields, they're often trying to assert ownership of the outputs there, or at least restrict or constrict how customers can use those outputs due to that perception of value leakage on their side. I'll talk a little bit about kind of rights to use customer data for training. Will touched on it in a SaaS sense. I think the market you can divvy up here a little bit. I think those application wrapper vendors who have built point solutions on large models actually tend to care a little bit more about using your data than maybe the big LLMs who've already trained their tools on wider corpuses of data and are at a point where they're doing very sophisticated training to generate the next version of their models. They don't really care about your inputs at this point for their training. It's much more sophisticated in 2026. But those point solution vendors, if you think about where you might operate in the market, you might have a lot of very domain specific data which is valuable to them when they're fine-tuning their tooling to solve particular problems in, say, financial services or life sciences or marketing or something like that. But set against that, it's still a pretty established norm that enterprise customers are expecting that any rights they give to suppliers to use their data is going to be opt-in only. So where do you end up? We're starting to see these side deals emerge to say, once you go through the kind of issues Will's worked through about what's aggregated and anonymized, is there a commercial upside or a quid pro quo to sharing in a safe way our data with these vendors for training, maybe just a lower price or some other commercial upside around that? And then if you do get to a point where, as a customer, if you're sharing in a limited, targeted way data with AI model system providers, in terms of the IP ownership of what they then generate in terms of a trained model, the IP in that, it's pretty established that they're going to own that stack. And in many cases, the people we talk to think sort of technically that probably makes sense, because if you think about what's gone on there, if by training on your data, they've improved a base model to become a trained model and adjusted a bunch of weights and parameters, is that really separable from what they brought to the table in the first place? It may make more sense for them to own it. On some of the more bespoke deals, as we see enterprises say, okay, we need more value and return from Gen AI, we might actually commission a Gen AI vendor to train or fine-tune a model for us, or do some other architecture like connect it to their databases to produce a more tailored result. On those more custom deals, I think IP ownership, or at least discussions around IP protection on what's created there, is more on the table. From the deals I've worked on last year, and there's been quite a few of these now, we've seen that it's often still the supplier that's going to own the stack in terms of the custom trained model. But what it gives the customer the ability to say is, look, we don't want you to have it having realized value from our data and then tomorrow go license this to a competitor and we've lost value from that. So thinking about some level of exclusivity or restrictive covenant, at least in a time or field limited way, on what's happened there, to give you the runway to, as a customer, to leverage the value of that before an AI provider can then go out into the rest of the e-commerce or retail or life sciences market to use that train model, is something we see a lot, even if it starts with an IP ownership discussion, but often ends up with the underlying concern of IP ownership, which is making sure my competitors don't get the value that I've given up there. And just to close off, Will mentioned data protection in terms of data here. I think quite often with Gen AI, we still see business teams at vendors say, yes, we do want to be able to train our models on personal data. And there's just an education gap there that we often feel to say, look, that's actually going to maybe tip you over into having controllership obligations, and legal and IG, information governance, get involved, and that tends to knock that one out. And most vendors are now accepting that they're not going to push rights to use personal data to train their AI models. And in the agentic market, again, it's nascent. You've heard me say that a few times now. I think there's sort of, on top of this, a few categories of IP or value that can arise with agentic. You've got the agents themselves, and sort of what are we talking about there? I think there's different parts of this agentic market that are emerging, different levels. On one level, you've got some providers providing agent capability out of the box that's been configured and could run workflows, and all they need is access to your systems and data and a little bit of boundary setting, and they're ready to go. In that case, those vendors are thinking of those just like their core software that Will explained with SaaS, and that's kind of fine as far as it goes. With the workflows, agentic workflows, I think in the first session we sort of understood that the components that are guiding agentic behavior are quite multifaceted. It's not just the original agentic code or model, it's a bunch of things, including things like the guidance given to it, the tools it calls. But what we're seeing is, in some of the agent provider terms, is to say, if the customer is contributing something, let's say you ask the tool to do more things within a workflow, run registration for an event, for example, if you're giving instructions that ultimately distill themselves into code, the suppliers are saying, look, we own that or have broad rights into that because we want to build that back into our workflow for value that we can sell to others. And most of the times we see customers concede that because they don't really perceive that as their sensitive data. It's more like a requirement that you've given that has then been encoded, either created by the agentic model or the provider, and then fed back into the system to improve it for everyone. I think that's where we are with the workflows. And then finally, just agent-generated data. I think we're getting the sense that as these autonomous systems act, they will create content and create code and things like that. And I think customers are insisting on ownership of that to the same extent they insist on ownership of Gen AI outputs, with the same legal IP limitations that sit around all that.
So the second contract issue that we looked at in our exercise was performance and accuracy. And here, what we're thinking about is the kind of commitments that a supplier of software will give you about the functioning of that software. And I think it's time for that theme to recur again, which is that what was once a fairly settled, fairly uncontroversial position is being challenged by the technology, and as a result is getting negotiated more. And I think it might just be helpful to explain our view of why that's happening. So if you see on this graph here, traditional SaaS I've put right to the left of the graph because it's a deterministic system. So for a given input, you know what the output of the system is going to be. And I put it at the top because if these systems go wrong, the risk to your business can be critical. It doesn't happen very often, but deterministic systems, that is traditional software, traditional SaaS, they do go wrong. And the consequences can be pretty severe, Post Office Horizon being the most horrific example. But even, if your payroll system starts paying the wrong people the wrong amounts of money, there is financial and legal liability there for you. But fortunately, it doesn't happen very much because these systems, because they're probabilistic, can be tested. And then thinking about generative AI is much further over to the right because it is probabilistic in nature. And what we mean by that is that for a given input, you can't say for sure what the output is going to be. You give it the same input 10 times, by design, you're going to get 10 different outputs, probably. But because of the way these have been deployed to date, we think the risk to customers has actually been pretty low because customers have recognized that this software is not necessarily predictable. It is going to hallucinate. And while we may not be able to get contractual protection on that, we can mitigate those risks through our AI governance. So whether that is acceptable use policies, or to be honest, in most cases, just having a human using the tool who can sense check the outputs. Obviously things do slip through the net, but by and large, having that person there has really helped mitigate the risk. And that's how I think a lot of customers have got comfortable deploying the software. And then agentic AI, even further to the right, this is arguably even more probabilistic than generative AI because you have that additional uncertainty over how is the agent going to go about achieving its goals, not just what is it going to produce. But if you think about what the promise of agentic AI, how it's being sold, all of those LinkedIn posts that you can't get away from on how agentic AI is going to change your business, the way that people seem to envisage it being deployed involves a level of autonomy for the system that just isn't there at the moment with generative AI. The idea is that you're going to have this AI agent. It's going to have maybe not free reign, but parameterized reign over a bit of your environment and be able to do stuff. And as soon as you have that probabilistic system with the ability to actually do things without a human checking, the risk level goes right up. So the way that customers have sought to get protection on the functioning of software, I think follows that graph, broadly speaking. Traditional SaaS, it was easy. You knew what the system was going to do because you could document it. If I put this input in, I'm going to get that output out. And you record that in the documentation. The supplier gives you a warranty that the software will perform in accordance with the documentation. Super easy, uncontentious. That's probably fine for most low-risk SaaS deals, but there are a couple of points that you might want to watch out for, especially with a higher value deal. The first being, has anybody actually looked at the documentation? Does it exist? Because the quality of your warranty, the quality of the coverage you're getting is entirely contingent on the quality of the documentation. And suppliers, some are great, especially legacy suppliers, I think it has to be said. Some are not necessarily that great. And also, have you thought about how that documentation can be changed? You'll have seen it. It's very common to see the documentation at a URL behind a login wall, usually, with a right for the supplier to change it, with maybe not even by giving you notice. Which, again, maybe that's acceptable in a low-risk scenario, but let's be realistic. The only time anybody is ever going to read this warranty again is if there's a problem with the software, at which point what is covered and what is in the documentation becomes quite important. In the generative world, that doesn't work so much anymore because, as you say, it's probabilistic. You can't say, based on this input, you'll get that output. So how do you get protection on the software doing what you think it's going to do, what you want it to do? We've seen a couple of approaches to this. One is that customers have moved away from wanting a warranty that it'll comply with the documentation, because the documentation will say, we don't quite know what it's going to do. It may be inaccurate. That doesn't help you so much. So instead, you look to warrant either the development of the system, or its design, or its testing, because those are facts that the supplier can confirm for you. Or you look at the other side, or I should say, you look at the other side, and you say, what technical mitigations have you got in place after you've got the output from the AI system to make sure that it is acceptable? So for example, if you were building a chatbot for a bank, yes, okay, you don't know exactly how it's going to respond to every customer prompt that could possibly be sent to it, but you can absolutely have in place mitigations, and you can give a warranty to say that it's not going to give you any expletives in its response.
Yeah, and agentic, I think, on this performance issue, it's very similar in a sense that we talked about the internal governance challenges of agentic earlier. I think customers are looking to their vendors to give them some levels of commitment to say, look, is this behaving as you expected? How did you train this? Did you assure it? What kind of guardrails have you provided out of the box? And almost for that same reason, in terms of Will's graph here, in terms of it having a higher impact if it did go wrong because of the way it acts and the real world harm it can cause, suppliers at the moment are in the stage of saying, look, we're not taking on that risk, and it's all on you, all on the customers to be responsible for the agent behavior. I think as a mid-ground here we're trying to pursue is similar to what Will was talking about with documentation, rethinking warranties to documentation in an agentic world to say, okay, you may not be able to write down a spec in the sense of a functional spec, but you can come up with potentially some baseline expected behaviors. What does good look like of the system happening? And try and set, sometimes mathematically, sometimes not, variances outside of that. So either SLAs or warranties to say, look, this is what we expect it to achieve. It's got to do this. We know we are putting some of our own guardrails in here. We know it's a little bit of a black box in terms of the accountability around it. We're expecting some vendors to stand behind this. So I think it's open to customers to push that, to say, look, it can't be right that this is no documentation. There is some sense and description of how this acts. Can we at least put that in the contract to have some security around that? So the positions are flexible at the moment. I think they're negotiable at the moment for agentic on this, especially the more sophisticated proofs of concept. But I think just as we were with Gen AI in maybe early 2023, when it was driving away some level of enterprise adoption because of these risk factors, which then evolved to give customers comfort, I think we'll get to a similar point with agentic. And there's a point over the top of this, really, which is kind of Will's point that it's all software. The delivery model of what we're talking about in this part of the market on AI is still delivered as a software as a service. So customers should still be asking for availability uptimes around, is this service going to be available? Is there going to be support? Are there SLAs around that for instant resolution and response?
This is what you came for. We're technology lawyers, and we could not resist talking about liability at least once. So what we've got here is our baseline. This is our view of what we think a typical liability position in a typical SaaS contract looks like. I appreciate there may be divergent views, but this is what we've seen. And again, the theme will be this is the norm and is starting to be challenged a little bit by the emergence of generative and agentic AI. So we'd expect to see exclusions of indirect damages, loss of profit, loss of data. That loss of data, customers sometimes feel a little bit nervous about that, and I think we see it more often than not included, but the way that we usually get comfortable with it and usually an obtainable mitigation is to carve out situations where the supplier is in breach of their backup or BCDR obligations. So at least you know you have them on the hook for that liability if it really is their fault. Loss of profit, this is a point for the suppliers. There are still plenty of US drafted contracts out there under English law that aren't breaking loss of profit out as a separate head of excluded loss. And those suppliers are potentially exposing themselves to liability for direct losses of profits, which is great if you're a customer. But customer caps, everybody wants them. They're pretty rare in supplier standard terms, don't see them very often. But I do find they are usually obtainable if you're willing to do a little bit of negotiation, especially if you're happy to carve out some of the key risks from the supplier's perspective, which are likely to be misuse of their product, IP infringement, liability to pay the fees, that kind of thing. In terms of the supplier's liability, general liability that is, 100% of 12 months fees remains the standard. It is the starting point in most supplier terms. Some will offer a little bit more as a starting point, but it often is negotiable. Obviously, so much is dependent on the nature of your deal and the relative bargaining power of the parties, but we've seen anything up to 300% of 12 months charges, and often with a liability floor based either on the expected annual contract value or sometimes just on a number that the customer feels is fair. And customers are often expecting separate treatment, I think fairly, of things like third-party infringement and third-party IP infringement, confidentiality, and sometimes data protection and security. Data protection and security separate caps are not usually offered in supplier standard terms, but again, you can get them if you're willing to push for them.
And on Gen AI, I think in the contracts we see the liability provisions that broadly mirror those SaaS positions really, except I'll just sort of add to it or some deviations from it. So if you think about the point that liability caps are what they are, but they've got to attach to something that you'd be looking at that's a provision that's breached. I think in the previous section on accuracy performance, we saw that as you get more up the AI curve, the more there's disclaimers and less responsibility taken by those vendors. So actually, if it did go wrong, could you point to a different clause to which you could then claim under a liability regime? Maybe not, because that was within the variance of that disclaimer, which is kind of interesting. And I think with Gen AI, we're still seeing those specific AI disclaimers out about it being experimental technology, about it being at the customer's risk, it causing inaccuracies, and excluding implied terms, things like fitness for purpose become quite relevant here because it's just general purpose, at least from the LLMs. I would challenge that a little bit in terms of the point solutions and the application wrapper vendors, because I think in a procurement exercise, you'd often ask yourself, well, can we just do this with Copilot or Enterprise ChatGPT? Otherwise, we're paying this vendor to provide a point solution. So presumably we're expecting a better output that's more grounded in our use case for that. So what have they done technically to make that happen? And why would this be better as a baseline comparison to Copilot or ChatGPT? They've done something. So whether that's grounding in data, running on Rails, whatever they've done, they've taken some level of operational responsibility to improve this for this domain, whether it's life sciences or financial services or an e-commerce chatbot, what have you. So I'd be saying to them, well, look, to the extent that you've not done that in a way that would be a better output compared to regular AI I can access today, almost for free, then we want the vendors to take some level of responsibility for that, for the data architecture they put in place, the pipelines to our data sets. If those things break or don't work and cause inaccuracies, we'd be looking to frame liability and risk around that. Indemnities, where are we now? I think all the big Gen AI LLMs are providing these, and then the application vendors flow them through, really. There's a few challenges here as you get up the stack. So sometimes infringing outputs are or are not covered. So I'd be checking that because they're not always covered, actually. And actually, that is where potentially as a customer, the risk lies in terms of you generating an output that then you use for your use case and other people get wind that might be infringing. We've seen the claims so far have tended to be against the big LLMs for training and the outputs that they're able to generate. We haven't seen that many on users yet, but that may come depending on the higher stakes use cases that customers put out there. And then there's a bunch of exclusions from the IP indemnities I think people should be aware of, depending on what their business model is. So in some cases, you don't get the benefit of the IP indemnity if what you're doing with the AI model or system is modifying it or fine-tuning it or building your own wrapper around it to do something in the market. Often that then obviates the indemnity protection. So that's something to be aware of. And in conduct of claims, I think those tend to get waved through, partly because the big LLMs want to be able to manage those, as we've seen in an earlier session. And just on risk, on those point solutions, it's kind of interesting. Like some of those vendors see the probabilistic risk around AI actually as not being their problem or their doing, because they're dependent on an underlying model that they say or then is delivering the probabilistic variance in the outputs that occur. I'd be challenging that again, depending on the deal, because you'd be saying, well, to the point earlier, well, we're procuring you and your solution because it would be better. You've done something there to ground this. And to that extent, I think it's a good argument against vendors to push that in there. I think on agentic, I think we've all sort of got a sense now of the different types of losses and harms that could arise from it acting in the world. So how's the market allocating risk here? I think I've sort of alluded to it, but I think there's three parts of this market at the moment. So there's the big software market that Will was talking about, the large enterprise SaaS vendors who most large businesses run on today for their mission critical operations. They're ideally placed to be releasing agentic features on top of their platforms because they're already in. They're already in your systems, in some cases running them, and have access to data. So what they're doing is they're saying, look, we can now, instead of just giving you a dashboard of all the IT incidents you have, we can actually have agents that get deployed to resolve them or remediate them. Now, when we've looked into those vendor terms and the addenda that we see, there's a lot of third-party LLMs that are running that functionality. And the contractual state of that has actually, from several clients now, have decided not to pursue proofs of concept even, because A, the data flows are really unclear through that stack, through those LLMs, and also just the contractual nexus is all over the place. So they'll say, look, it's not even passing up through the stack, those vendor terms. It's saying, we're not responsible, go see Gen AI provider terms. And that's unclear whether you even have a contract with them, never mind being compliant with GDPR Article 28 there. I think another part of this market, I've sort of mentioned that the idea that there are agents that being sold that could run largely out the box, they just need connection to your systems and data. I think for those, we're still seeing those vendors disclaim a lot of responsibility. I think that will have to evolve to drive the enterprise adoption. They'll have to say, look, if this is going to work out the box, then we have to stand behind much of what we're able to do with some assumptions, with some conditions on user guardrails as they're set. Or if the user's selecting other third-party tools to call to, which is within the gift of those, then they're not responsible for those. So a bit of a shared responsibility matrix, I think, will emerge there. And then you've got agentic environment platforms, more like development environments, where product teams want to license them in to say, because they say, as part of the customer organization, we think we can develop our own workflows and our own agents in that way. In that case, I think the vendor market is treating a lot like cloud infrastructure to say, look, we'll provide an environment, we'll give you commitments around the environment's availability and the function of the environment to allow development to occur. But what you build in that is your responsibility. And at this point, that's probably just about fair enough. So I think that rounds off the liability infringement section.
Yeah, I mean, I might make one more point just before we leave the slide, and you can shout at me later. But this is everything, right? Like, you can have the best contract in the world, you can have the supplier nailed to the wall, offering you all kinds of commitments on AI compliance, on software performance. But if their liability is capped at 100% of almost nothing, it's not necessarily offering you the protection that you think it is. So we've dived into a few areas, but we thought it'd be useful just to give a few key themes or key takeaways. The first of those being that, as I think you've seen, in the traditional SaaS world, market positions are pretty stable. There is a norm. That doesn't mean that you can't negotiate it, and it doesn't mean that the supplier's terms are always appropriate or low risk. There are plenty. We've been doing this for 20 years now. There are plenty of SaaS standard terms out there that are getting really old, really creaky, and do need to be updated. And like Vic was saying, it's all software. Like, the basics still apply, whether that is remembering that, as well as all of the, it's very easy to get distracted by the marketing, the new risks from the software, but ultimately you still need things like availability service levels, a commitment to support, like to think about your liability position. And on the flip side of that, I think it's fair to say that on one or two occasions we see that both customers and suppliers have on occasion overcomplicated things, I would say. I was working on it was actually a really fun mainframe deal a while ago. Had nothing to do with AI, absolutely nothing. It was sort of like coal-powered, big iron, oily rag kind of old-fashioned mainframe software. And it took us about 3 rounds of negotiation with the supplier to get them to concede that actually we didn't need to review their standard AI addendum in full and negotiate it. So sometimes it really is just simple software.
Couple of final takeaways. So I think the Gen AI positions 3 years in are evolving and quite well, are sort of settling in some key areas, but there's some residual complexity, I think, on some of the IP and data rights and also the IP indemnities. I think just need understanding the limitations of those. They're not a panacea. And on agentic, it's nascent. The risk positions, I think you can think of how good a position you get as a customer based on how much autonomy there is out of the box. Higher autonomy, higher responsibility for suppliers in the end, I think, as we get towards the end of this year. And lower autonomy because it's up to you to build as a playground, more customer responsibility and more leaning in internal governance. And then final point, which is a general one, as ever, positions achieved are going to depend on the solution and bargaining power and things. I think the important thing on this one is really that sophisticated customers kind of get they're not going to be able to shift risk to customers in the way they might do in an outsourcing, even with agentic. And even when agentic might replace some outsourcing and managed services. And there's an understanding of the limitation of how contracts can get, but there's places to push. And I think the state of that will improve and give more customers more comfort.